But thank you for that information. Yes. Changes.
Hey, thank y'all for coming. Good seeing you always.
So, Amanda, check with Amanda to see if it's posted.
Morning, Rachel Roden.
Yes, I'm good.
Okay.
Take care.
So do you have paperwork for us? You have paperwork for us? That's fine.
Okay, good morning. We're all ready. We're gonna call the comprehensive plan workshop to order. And our consultant here is Brandon Stubbs from North Florida Professional Services, and this is a workshop presentation from them.
I want to try to, I guess, is this the PowerPoint? Okay. Good morning, Commissioners. Brandon Stubbs with North Florida Professional Services. It's my colleague Justin Tabor. He's a senior planner with North Florida Professional Services. And we're here to workshop the proposed subdivision regulation items. And after my presentation, what I would like to have from the board is any questions, comments, or anything that y'all seen that maybe you want, that you like, don't like, or want to see proposed in this draft regulations. All right, a couple items that I want to address before we go into the what we've been working on is last year the Senate adopted Senate Bill 180, which basically limits local governments on what they can and can't adopt. So essentially, Helene, Milton, Adelia, they took those three hurricane events and said anywhere from 100 miles on either side of that hurricane track, those local governments cannot adopt any regulations to the comp plan or LDRs that are more restrictive or more burdensome than the current comp plan and LDRs. The other thing is that has prohibited local governments like Bradford County from being able to be in compliance with existing state statute requirements. So this statute overrides home rule for local communities for comp planning and LDRs and making new regulation. There is a current Senate Bill 840 that is hopefully going to, quote, fix this issue. It's not adopted yet. It's still going through the committees, but this will be a glitch bill for Senate Bill 180. And if this should be adopted by the Senate, it would allow local governments to adopt comprehensive plan amendments and land development regulations to comply with state statutes. So that would fix the comp plan issues and LDR issues as far as compliance with state statute. It would also allow local governments to adopt comp plan and LDR related issues related to floodplain management. In other words, if there's criteria that you have to adopt to come in compliance with any FEMA requirements or any updated stuff. It also reduces the affected area from 100 miles from the track to 50 miles. And then the greatest part of this is it limits the prohibitions for adopting new, more burdensome or additional regulations to 1 year after the hurricane event makes landfall. So it's looking at Bradford County, that would probably be in June sometime of 2026, if this was passed. But again, this is just, we don't know what's going to happen right now. Currently, as these regulations are proposed, that it does violate Senate Bill 180. So there's a decision this board has to make on how to proceed forward with your legal counsel.
Madam Chair, if I may, Brandon, could you explain a little bit about the, how the 100 miles versus 50 miles swath relates to the storms and what exactly that means?
Yeah, so y'all know every hurricane has a path. And currently, Senate Bill 180 says anything 100 miles on either side of that path is an affected community. With Senate Bill 840, it would reduce that to 50 miles on either side. So not only would exempt certain communities that are currently affected, but it would also provide for the 1 year limitation. So,
but I believe one of the storms, I can't remember which one, would still encompass Bradford County, because even with.
I believe that was Idalia, if I remember correctly. I have to go back through, but yes, there is one that currently does, even with the 50 miles, affects Bradford County. But the hope would be that if they do adopt this, that 1 year period would end in sometime in the mid-2026. Do you have any questions about that, or I know your attorney had some concerns about that?
You were saying that the 840 would fix the 180, is that what you're saying?
For a lot of local governments, it would provide a lot of fixes, which would be your current year amendments, your evaluation appraisal report for your comp plan is due, I think, in September. Currently, if we were to do like an update to your comprehensive plan to comply with state statute and comply with the statutory requirements for your evaluation and appraisal report, we could not do that. We would be, so right now it's kind of a catch-22, because if you do it, they're going to send you a notice saying you're out of compliance, and then if you don't do it, they're going to send you a notice saying you're out of compliance. So essentially, Senate Bill 180 is causing a lot of compliance issues with local governments because they cannot comply with state regulatory statute and update their comp plans and LDRs. So yes, this does fix a lot of those issues. It doesn't fix everything, but it does fix the important issues, which are basically the updating your LDRs and your comp plan to comply with state statute, being able to comply with any additional or new regulations on floodplain management, and it also provides a shorter limitation. I can't remember off the top of my head, but I think currently under Senate Bill 180 it's like 2028 before you can make any changes. So it's pretty impactful.
I think it's, Madam Chair, I believe it is October 1st, 2027,
Okay.
which is close to 2028, obviously. In other words, if nothing happens, then between now and October 1st, 2027, you could not make any changes that are more restrictive or burdensome on a property owner than is current language in your comprehensive plan.
And I believe the reason that this is so pertinent for us is because the restriction that we're talking about placing on subdivisions where we're requiring paved roads would be more restrictive.
That would trigger, if you were to pass such a regulation under the existing statutory scheme, the existing state statutory scheme, if you were to pass such a regulation dealing with subdivisions, then it would not be valid, and so you would need to wait until October 1st, 2027 to pass such a regulation. Now, if 840 is passed this legislative session, there would be more flexibility created for local governments to do things like the proposal to require paved roads and subdivisions. Hopefully that gives the exact impact of this legislation, this proposed new legislation on what you're trying to do here. Just trying to be as simple as possible, not and in terms of its real world effects on the things that you can and cannot do.
So the two things that I would like to have addressed directly at this workshop, so that we'll know how to proceed going forward. Number one is the question about making the LDR more restrictive, and the other is to how to deal with the compliance issue. And what I'd like for Brandon and Justin to do is more or less paint a picture of what it would look like either way, whichever option you guys decide, so that you'll know what you're getting into in terms of unintended consequences and the other things that go into the decision.
You can certainly talk about the things that you would like to see occur, right? And they can't stop you from talking about these things. And be prepared to act when state law will allow you to act, right? And I'm not really sure that the ear issue is a problem with the state, in the sense that all you're doing is really just collecting data, reporting data, and talking about things that have already happened.
I know several communities have been denied their ear updates, even though they were just updates to comply with statutory requirements. They're
probably depends on what's in the ear.
Yeah.
But anyway, and that's all fine. That's not really, I mean, to my knowledge, unless I'm missing something, I think what the board is wanting to consider is beyond ear, and with the paved roads and perhaps other things, which understood that you would want to do that. And I understand your policy decisions and I mean your policy reasons for wanting to do that. I'm saying that putting aside the ear discussion, because I don't think it really, at the end of the day, is going to be of much concern one way or the other for this particular board. The ones that you're really concerned about, the paved roads or anything else that you're looking to do to update, those are the things that what we're discussing about the state law. Those are the decisions that it really affects.
So, so we can't really make any decision other than recommending what we'd like until we actually know what's passed and not.
You got it.
Okay.
I think that is absolutely correct. And yes.
Yeah,
I appreciate your frustration. I would be frustrated if I was sitting in your seat. My job is just to report what's going on, but I hear you. If you're frustrated, I get it.
When will we know about 840?
Well, the session will end in about 5 weeks. Remember, even if 840 passes, it may pass and not include that provision. You know, that provision could be amended out. I know that to take off my attorney hat and put on my observing the legislature hat, this is a heavily understood and discussed issue right now. In other words, all the local communities have expressed concern to the legislature, and then the individuals who are property owners have expressed their concerns to the legislature, or their satisfaction with the idea that local governments are precluded from moving forward. So they're hearing both sides. They're fully understanding of the concerns that have been raised by both sides of that issue.
Yeah, and I think to get to that point, the purpose of 180 was to be able to allow people to build back their homes, right? But the unintended consequences went way beyond what the bill intended. So what this bill is trying to do is fix that.
Yeah, but so, I mean, not to be cynical, but I've been over there. what was one person's glitch bill is another person's, we're kind of happy that these changes can't be made. All right, I mean, let's be real.
Understood.
So I don't know what's gonna happen. I think it's less than a 50% chance that 1 year, limit prohibitions 1 year after a hurricane. I think there's less than a 50% chance that is included in a final legislative. I think you should proceed with the idea that none of these things are gonna be in effect until October 31st, 2027. I think that's the most likely outcome. That would be my professional analysis. As an observer. Doesn't mean your local representatives don't sympathize with you, but they're 1 of 40 and 1 of 120.
So this time I'd like to go through a brief presentation of the issues that we have currently addressed. And then if you have questions about specific language, we can go into that. Hopefully everybody has gotten a copy of the proposed language that we submitted, and then we can talk that in detail.
No. You have that?
Okay.
If you can provide us a copy of the sign.
Ms. Brown's gonna make some copies. So the first thing that we did was we wanted to align Bradford County's subdivision regulations with more of the regulations of its peers, what other local governments have done to address the same issues that Bradford County has seen, which is subdivisions that don't have proper infrastructure, that are costing the taxpayers money because the commission has to come in and fix roads, fix utilities, or sidewalks, whatever it may be. So the other was to bring the LDRs into compliance, or the subdivision regulations in compliance with recent statutory changes. And this was through like the mandated changes for plats to be administratively approved. There was a statute that was passed last year as well that basically said that all plats are basically administratively approved. And so this rewrites the process for approval of preliminary plats, construction plans, and final plats. It also establishes an administrative process for that plat approval. So the statutory requirement says you have to have administrative authority that approves, denies, or approves with conditions plats. It also has certain language that they must find if they were to deny a final plat that's been put in there. We've updated the paving requirements to conform with modern development or paving practices, including update of pavement types. Like I think originally y'all had a type 1 asphalt concrete. They don't even use that anymore. So that's out of date to say you got to use this concrete, this type of asphalted concrete when it doesn't. They don't even make it anymore. So that was changed to basically update the modern standards for concrete. The next thing was to establish a special assessment district. And what that is what's called an MSBU, or Municipal Service Benefit Unit. And that is a tool for the commission and the county to use should a subdivider come in. And as you know, there's always the issue of, well, how are we going to maintain this road in the future? What's going to happen to it? Where are these funds going to come from? If it's got water and sewer, who's going to maintain that? Sidewalks, anything like that. It could be stormwater. So it provides a mechanism for this board to establish a MSBU, which is a special tax district, so that when the subdivision is created, every lot would pay into that MSBU. The MSBU would be dedicated specifically for that purpose within that subdivision. Let's just use road paving as an example. So, the MSBU would calculate, all right, this road is built today, but in 20 years, it will have to be resurfaced. So what's the cost of resurfacing this in 20 years? And then you assess a per lot basis on an annual basis. So in 20 years, you got a pot of money set aside for repaving that road.
Yes, but would we be allowed to do that? Because that is more restrictive.
I don't know that that would be considered more restrictive. It's a tool that is available today, whether, I would argue whether it's in the LDRs or not. The LDRs just solidifies the fact that is a process that you can do. There's a statutory process already available for local governments to establish MSBUs. But this would solidify the fact that the developers expected or required to do that.
Yeah, I think that's a really good point. It's more of a financing mechanism that exists now, that you can utilize now, and you're just codifying it.
Correct.
And that's kind of, and I want to simplify, not make things foggier or more confusing. When I said what I said earlier about the EAR report, what I was talking about is to the extent the EAR report that you're mandatorily required to provide by September, to the extent it doesn't include anything that is more burdensome or restrictive, then that EAR, they would accept it, and it would be you would be in compliance with that part of the statute, and you would be in compliance with the rule that says that you're not allowed to do anything more restrictive either.
And when are you allowed to do, at what point are you allowed to do that? When does that come in play?
What's that?
The fee that you're talking about?
That comes into play, so before, right when you're going through the final plat review is when you would want to set this tax district up. So before the final plat is approved, you would want to have this special assessment district in place and have everything adopted.
You can do that under law as we speak here today, and that's his point, and I agree with it, that I don't think that this is more burdensome than existing, but this would just lay it out there.
Yeah.
And provide the roadmap so that it's almost more of a codifying so that people know what to expect kind of situation.
Exactly.
So I'd be interested to say if we send it off, what the response would be from the Department of Commerce. Like, we can't guarantee this. We certainly have a colorable argument that it is not more burdensome or restrictive than your current options, as we sit here today. You see? So I would be comfortable with your ear. I would be comfortable sending off an ear and that being included in it. I would want to see the final look at it, or Rich or I. I think that would be something, for instance, that y'all could go ahead and move forward on right now.
Well, because we've got houses coming up.
Understood.
And being developed, and if we can't do the road thing, which
Right.
obviously we can't, we're gonna have to put that in play, or I don't know what we're gonna do.
I would argue that you can currently do that under statutory
Right.
requirements. So again, if somebody came in today with a subdivision and they had to pave 1,000 foot of road, you could require them today under statutory requirement to put that in an MSBU and do that regardless whether it's in this, it's in this amendment or not. Like your attorney said, it's a matter of when they're reading, what do I need to do? They understand that they're going to have to do this instead of just staff telling them that they're going to do this.
Right. I agree with that. I'm also not an insurance policy. I give you advice. So, we'll see what the Department of Commerce says, but I would do it.
If that's the will of the board, I'm
Yeah.
saying, don't do what
And
you
if
want
there are
Right.
things within this proposal for the subdivision regulations, because this is an LDR amendment, it does not go, this specifically does not go to commerce. They don't have to approve this. But there's things that we go through here, and this board and the attorney and the county manager, everybody agrees, we could probably go forward with a draft of this that only addresses like things like this that are not more restrictive or burdensome, and then come back later with the additional items, because the process that for adoption of plats is actually less burdensome, so that would not be an
Right.
issue. The process for the MSBU's, and there's other things in here that I would consider that are more administrative things, that could be adopted, that are not more burdensome or restrictive. So there's some things that we could look at, and, if the board feels like y'all wanna proceed forward with what we can, and then we can come back later with the things that, yeah, well, that's definitely gonna be more burdensome. As far as, amending the type of asphalt and the thickness is questionable. Because like I said, we did modify it because the old asphalt types, the type 1, the type 2, type 3 asphalt, they don't use that anymore. That standard's long gone. It's like a SB1 or SB2. So what we did was we took the equivalent and we put it in there under the new terms and adjusted the thickness. Now, whether or not somebody considers that more burdensome or equal, to me personally, if I looked at it, I would consider it an equal exchange. But somebody may not look at that. That's a questionable one that we might have to sit down and explore a little further. Obviously requiring subdivisions that currently are exempt from paved roads to pave them, that's more restrictive. That would obviously not be able to be put in. There's other things that are in here that I think we could put in, and that is the lot split process and the division of land process, because I feel like those are actually less burdensome than doing like a plat, which is currently required. So I'll go over that in a minute, but I want to let Justin talk with you about some additional items.
Madam Chair, before we move on, just a couple of things. First of all, I agree with Senator Bradley and Brad that we should probably go ahead and do what we can in the meantime, and then face whatever we can't do later down the road when it becomes available. And also, Brandon, a question to you regarding MSBU's. You guys are situated or positioned that you can help us if the board decides to create MSBU's in the future, is that right?
Correct. There's so much that we can do, but unfortunately, a lot of it has to be done by your finance department, because they have to set up the account. It has to be a specific account with a GL code that is specific for that subdivision and that district.
Understood, but you'll provide the professional guidance and administrative help that would take the clerk's office to establish that.
Correct. Yeah,
Okay.
we can help with that.
Got it?
I think he's talking more about the calculation of the cost, rather than the collection of the monies.
Yeah, now, our engineers can do a certified estimated cost for that kind of stuff. My recommendation is, eventually what I would recommend is for this board to come up and have a set cost for like, how much does it cost for a linear foot of asphalt paving or resurfacing? And so that you'll know exactly what you're going to be charging. So if they have it's $2 per linear foot of, and this is not real math, I'm just example, but if it's $2 for a linear foot of asphalt for paving and you got 1,000 feet, well, you know, it's going to cost $2,000, so you need to collect $2,000 over the next 20 years, and you got 50 lots, and you just divide it up amongst the lots. It's very simple math, but it's coming up with a cost of everything that you're going to be assessing. So if it's sidewalks, if it's stormwater, if it's, roads, it will be, coming up with a, cost, to, some quantitative method to know how much you're gonna be assessing each, property for that subdivision.
So, for this board to come up with that kind of cost analysis, we would need the input from, from our road department who deals with those minute details in terms of what concrete costs or what asphalt costs. I mean, I wouldn't know that. So we have to have some guidance in that direction to come up with a reasonable cost without just a guesstimation.
Correct. And so this is where you can do it one or two ways. You can have a study done, and you can adopt a general study, or you can, at the time of subdivision, you have a county engineer, they have an engineer, engineers, or we come up with a certified cost of construction all the time for projects. So what they do is they look at the current numbers and what it takes to, what's the current price of asphalt and how much it would cost for a linear foot to pave something, and they can give you, like, basically per subdivision, you can have the applicant's engineer do a certified cost of maintenance for that first 20 years, and that's what you can have your engineer review to make sure they're in agreement, and if everybody's in agreement, then that's how you can come up with the numbers. Otherwise, you can adopt an ordinance that specifically adopts certain improvements like sidewalks, curb and gutter, paving, stormwater inlets, things like that. Anything that might be given over to the county for maintenance, and then they can assess that either at the time or to an ordinance that establishes a certain quantitative fee per, would be linear foot of pipe for each type of pipe, or vice versa. So there's a couple ways to establish it. Being that plats are more fluid and things change a lot, like unless you want to go back every year and be updating an ordinance, which is fine if y'all want to do it that way.
No, that's, I think the better way, taking into account what would be required of the staff and the board, I think that you want to have more flexibility, that so you don't have to go back and revisit it over and over again and
Correct.
produce new numbers and produce new numbers and produce new numbers.
Yeah, and that's where you would get every time somebody submits a plat for review, at the time of the construction plan and final plat approval, they would have to submit an estimated cost of maintenance for every public improvement. And then that's what you would base your MSBU on.
All right, and then you would have the opportunity, it needs to challenge it if we think that it's,
Yeah,
the government would have the opportunity to, there needs to be a process where the two sides resolve,
Yeah.
because they're gonna say they want it cheaper and, all that. But that just needs to have that set forth. You probably have something that does that, correct?
Yeah, so currently, what we have is it's section 5.20.2 special assessment districts, and it's for a condition of final approval of any subdivision which is will be constructing paved roads, which may also include sidewalks, stormwater management facilities, and other associated improvements to be dedicated to the public to transfer to the county for county maintenance. The developer shall consent to the creation of a special assessment district pursuant to Article 2, Chapter 70, Bradford County Code. The boundaries of the special assessment district shall be the defined and platted boundaries of the proposed subdivision. The purpose of the special assessment district shall be to establish an assessment on a per lot basis.
Can you
interrupt
say,
you for a second? Are you reading our current,
This is what we're proposed, this is
what
we
page and
proposed.
what section are you?
This, page 13, I'm sorry, section 5.20.2.
Okay, you're reading what you're proposing to do, is that correct?
That is correct.
Okay, this is not what we have currently.
Currently, there's nothing in your code that addresses the special assessment district, so,
All right, and you're saying that you would like the board, or you're offering to the board the idea that this become an ordinance that they adopt?
correct.
Okay. What would be stopping them from doing this? What would be the negatives of that?
There is, I don't know of any negatives.
All right, so the next step would be to have an ordinance that includes this language for their consideration, correct?
Correct, so this, all this right here, the subdivision, this is a draft of what would be in the, basically the section 1 of an ordinance, or a resolution and an ordinance, a resolution by the P and Z, an ordinance by this board, that would be adopted, proposed for adoption.
Well, it looks like there's other things in here other than what you just read.
Correct, there's a bunch of changes.
And some of the other changes are, you would agree are restrictive,
Correct.
right? So could you prepare a document for their consideration that removes all those things that are obviously restrictive,
Yes, sir, yeah,
but only contains those things which they could move forward on now,
yes, sir, that was,
such as what we're talking about right now?
yes, sir.
Okay.
Yeah, it would be a two-phase process, and that would be, like your attorney said, the first phase would be adopting anything that we can adopt, like procedurally, that is less restrictive or more restrictive or burdensome, and any language like this, which is already provided for you in statute, it's just solidifying it in your code to let the developers be notified that this is going to be required.
Brandon, would it be a 2-phase or a 3-phase project? Because you mentioned earlier that there are some things that would have to be sent to the state for approval. So it would be,
Not for this.
Not for this.
Not
This
for
is
this.
for land development regulations right here. This is just only local. The things that need to be sent to the state are the required EAR report, right? Because that's due.
Yeah,
On the EAR report issue, you have to talk about things that need to be updated and all that kind of stuff, right?
yes, sir.
And you prepare that as well?
Yeah, we are currently in negotiations with the county to prepare their EAR, which the first step of that would be preparing what's called a data and analysis report. And that data analysis report has to be based upon the 10 and 20-year planning horizon. And then we would update your comp plan for the 10 and 20-year horizon. Most of those changes are not going to be they're not going to be more restrictive or more burdensome. It's just showing the planning horizon. But there may be goals, objectives, and policies that we can't amend because even though they're required by statutory requirement to address, they might be considered more burdensome. So the comp plan will probably end up, depending on what happens with Senate Bill 840, will probably have to be a 2-step process as well. One, just adopting what we can and do the 10 and 20-year planning horizon and meet all the EAR requirements. And then 2, come back to adopt once we can. And
Because we're no longer burdened by the state requirement that it can't be more restrictive.
yeah, then come back with any other requirements to address state statute that may be more burdensome, as well as any other items this board wants to address. So, and then this would also be a 2-step process based upon kind of what we're discussing now. And again, it would be adopt what we can, get what we can on the record today, and then come back later and adopt the rest of those amendments in the future date.
So, if it can be as clear as mud for me.
Okay, well, there's 2,
So,
go
so
ahead.
one would be to prepare what we can without the least restrictive.
Yeah, anything that's not more restrictive or burdensome.
Okay, and that would be the first phase.
Well, right, I would do it like this, Chair. You have your things that the state you have certain actions that the state is not involved in. That is how you handle your own land development regulations, all right? So, when it comes to that, this is a document that includes proposed changes to your land development regulations, has nothing to do with the state, right? And, but included in here is some things that are clearly more burdensome to a property owner. So therefore, that can't be done right now because of state law, right? So he's gonna prepare a document that has only the things that are not restrictive or burdensome, or more restrictive or more burdensome. He'll prepare that document. He'll also put in a bucket off to the side all the things that you would like to get done when you're able to, because that restriction from the state is no longer applicable. Do you see what I'm saying? So the next step will be him providing the board for consideration a document that includes only those changes to the land development regulations that do not run afoul of current state law.
Okay.
Right? But he'll also have available this other document that includes all of the things that you would like to do when you're able to do so. All right? Okay? Those are land development regulations. Okay? Done. Now you have what you have to do with the state, which is this EAR report they keep talking about. All right? He's going to prepare something for you to consider to send to the state. Included in that is going to be nothing that, again, triggers this idea that, hey, we're planning to do things that are more burdensome or restrictive. Also, they'll put in another bucket to the side things that an EAR report would look like that you'll send later once you're able to do so. That includes all the things that you want to do that you can't do right now. So I see is that fair?
Thank you.
Exactly.
Right.
Yes.
Okay,
Thank you.
so you have your LDRs and then you have your EAR. EAR goes to the state, LDRs stay here and never leave. Both processes are gonna have two buckets. The bucket that you approve, that change your LDR, and the bucket of things you're gonna consider in the future once you're able to. The EAR, you're gonna have the bucket you're gonna approve to send to the state, and the bucket that you're gonna hang, it's gonna have things that you wanna have available for you to send when you're able to in the future. All right?
I think I got it. LDR home and EAR state.
Yeah.
I have a question.
Any other?
Yeah, we got some, a little bit more, and
Okay,
then if y'all want to open up for public comment.
okay, we'll come back. We'll come back to you.
So before I move into the next part, if we could maybe just go back one slide, I think I've tried to, let's see, I'm running here, sorry. Okay. And I'm kind of looking to the attorney just to give his agreement too, that he thinks that these would be of the category that are not more restrictive or burdensome. So
I would need to see like the actual language.
well, okay, that's.
I mean, I
that's
can't
fair.
give you on the fly.
That's fair, but as far as just
Termination.
with these bullet points, if, can I at least just call out the ones that we are flagging right now?
I mean,
That's fine.
I'm not trying to be coy or avoid anything. I'm just saying that
We just want to make sure we come back with the.
I
right
trust
people.
that you,
Okay.
that with your experience, matter of fact, you'd be more experienced than I, because you've seen how other communities are dealing with this with
Sure.
your professional lives, and I've only seen a couple. You've seen more than I have.
Well,
But
we can do that.
what I understand to be the case in whatever the wishes of the chairman and the board is that all these things we're talking about, these are things they've already communicated that they would like to see, talking about the
Correct.
board. And if it turns out that you've got something that you provide them that they've decided that they've evolved and thought better of, they can do it when they consider for final approval what they want to do with that.
No problem. Okay. Okay, so moving on, so the proposed amendments that we've presented to you would establish a lot split procedure for lots of record. So a lot of record as is currently defined in your code is a lot that was in existence at the time of the adoption of the comprehensive plan, which was, I believe, a date in December of '91. So right now, it's not really clear in your code that you can come in outside of the subdivision process and split off a single lot. This would provide a procedure to do that if the lot is a lot of record existing prior to the adoption of your comprehensive plan, which again was December of '91. Next, we're proposing to establish a master planning and phasing procedures. So this would be an optional component, which again would likely fall within that category of less or not more restrictive or burdensome, something that you could proceed with at this point in time. The next point that we are proposing is to create a division of land process, which would be applicable for lots that are 10 acres or greater and also less than 20 acres in size, providing development criteria for that. So in these instances, it would be akin to a subdivision, but would not be a formal subdivision plat. You wouldn't be creating streets. Access would be through easements that would be privately maintained. And again, I would probably contend at this point that would be within the bounds of what we're currently operating with Senate Bill 180. We are also proposing to provide a mechanism for surety instruments. So the surety instrument would be provided for one of two scenarios. The first would be in instances where the developer is constructing the infrastructure prior to the final approval. They would put up a construction surety instrument. The second one, which is more important ultimately for the board, would be a maintenance surety, where they would provide a certain percentage, usually it's 10 or 20% or in that range, to cover the first year maintenance. So if you have a sidewalk that fails, if you have a pipe that fails, you're able to recoup that cost if the developer fails to fix that on their own. The next bullet point, requiring all work and or construction performed by a contractor to be licensed with the state of Florida and pre-qualified with the Florida Department of Transportation. Again, that would be more of a safety net for you, knowing that the contractors that are doing the work are vetted through FDOT's process. Next, provide for inspection schedules, coordination with the county engineer, and the submission of as-built plans following final construction so that you have a record of what's actually on the ground. And lastly, it's time to catch-all, address other statutory changes, including those that pertain to timeframes for review and comment on application. That's based upon some statutory changes that were presented last year, I believe it was, as far as the review and commenting on applications. So that's kind of our run-through of the summary for the board. We're happy to answer any questions that you may have.
It's still a little Greeky, but we'd like to be able to absorb it
Yes, ma'am.
a little bit more. But you guys are the expert in this area and making sure that it's also clear to us, and then we can articulate the things that we desire more clarity on.
Yes, ma'am.
But I know that we'll have to employ our engineer folk in helping us calculate numbers for.
Yes, and those can change over time. You know, the cost of construction usually, well, I won't say never goes down, but usually never goes down. So again, we discussed as far as those being presented, and you certainly have a verification process through your county engineer that I think can work to make sure that you're covering yourself on each instance.
Okay. And our attorney helped to kind of clarify for us the phases in which we're proceeding to know those things that rest with us at home in terms of what we can do in our plan, and those things that we have to have approval from the state.
Yes, ma'am.
To do.
Yeah, I think we can come back to you and through the city manager or the county manager's office in coordination with the county attorney, make sure that what we're presenting to you doesn't fall within one thing I don't think that I've heard really is the terms are very subjective. What's burdensome or restrictive to one person might not be to another. So it's a balancing act, but I think working with your staff, we can certainly come back with something that we all comfortably feel is within that realm of reasonable certainty.
And so we know that, well, I guess in the next 6 to 8 weeks,
Right.
have a better picture of how
Yeah,
things work.
I think, Madam Chair, the next time you visit this issue, if it's your pleasure and the board's pleasure, would be that there will be provided to you a document for consideration, all right? That would be an amendment to your land development regulations. Contained therein is going to be matters that are not running afoul of state law, all right? That'll be the next thing before you.
Okay.
Around that time also, there'll be a proposal to send to the state for what we're calling the EAR report, which is a statutory requirement of state law. Also included in that document is not going to be anything that would run afoul of state law, right? During that time, we'll have an open discussion about the fact that this is not the end of the road for this board in terms of how you want to deal with these issues. You're going to want to do some more things in the future once that you're free of the restrictions that are currently contained in state law, right? That will be explained during the presentation in your consideration and in your materials, what is in the category of to be approved today, and then what is in the category of to be considered in the future once the state doesn't restrict your ability to consider those things. Hopefully that.
Yeah, so in terms of the next board meeting, which is 2 weeks from this Thursday? 2 weeks from this Thursday is the 19th, I believe. So Brandon, Justin, can we have these things that the county attorney has articulated ready to put before the board for their consideration at that time? Or how do you see this going forward?
Well, given the restrictions on one, advertising, two, the PZB has to have their local planning agency hearing prior, and then it goes to the board.
I think they're their own local,
Because
they're their own local planning agency, I believe.
to be comfortable, I'd rather us come with a draft and send it to.
Okay, here's what we'll do. We'll send your draft to Scott, okay? We will have one agenda item on a regular board meeting as saying that, are y'all good with this? And if we are, we're gonna advertise it.
Okay.
All right?
Yeah, I would just.
Does that sound like because
Yes,
that gives you plenty of time to review, consider all the above.
yeah. And consideration on the 6th of March, we're gonna have our first, workshop,
Budget.
the budget workshop, but on that same day, we'll have our regular board meeting.
Perfect.
So would it be more reasonable
Yeah.
at that time, on the 6th of March, to have?
March 6th, we'll have an agenda item where we say, this is the draft
Yeah.
that we're gonna go forward, and by that time, we hopefully will have some idea about what the legislature has done too,
Yeah,
right?
yes,
Of course,
That's instead of the 19th.
instead of
instead of the
19th.
19th.
That's
Have it
right.
been March the 6th.
Yes, March 6th.
And that would be the time frame in which we should probably know something from the.
Right, well, and also, but even if it passes, it still would have to go to the governor, so it could be a veto. I respectfully suggest that we should go ahead and move forward as described, where we just go ahead and just do the stuff that doesn't run afoul of state law. Nothing keeps us, if things go perfectly, of having another hearing and doing all the stuff we wanted to do, if everything works out perfectly later on in the year. You see what I'm saying?
Yeah.
But let's just go ahead and move on, like, this is the world we're gonna have to deal with for the next year, I would suggest.
Well, we'll put together our draft of what we feel like is more burdensome, more restrictive. We'll send that to the county manager and the county attorney for review, make sure they're in agreement. And then once we're all in agreement, we'll put just like this, a proposed, a proposal before you that shows all the proposed additions, deletions, and all that, and the changes. And if y'all are happy with it, then we'll move forward with advertising for the PZB and the commission meeting, which will be all on the same day. And that'll be first reading, and then we'll have to come back for a second reading.
Yeah.
Okay.
So realistically, you're probably looking at April, mid-April.
Yes.
That's right. And at best, not because of anybody dragging their feet, just
Yeah.
because you have advertising and things you got to do and all of that. So on the 6th, which is a month from now, they're going to have a document that if they say grace over and this is what we're wanting to do, then that starts the clock of us advertising and doing all the things we need to do to turn that into law.
Madam Chair, if I may, Rod, do you have any questions or concerns about anything you've heard?
No.
It's all good?
Yeah.
Okay.
And Ms. Strong had a comment or something, and I did tell her I'd get back. So
Yes.
what is it?
Okay, so.
Vyanda, go up there so we can hear
So we can hear
you,
from
please.
her.
So the city of Lottie doesn't have any subdivisions, and they don't have a plan. So how does this affect them with their plan?
This is for the county
Exactly,
that was
but,
loaded.
right, but with it being restrictive, they don't have a plan. How would that affect them? With being restrictive or not?
None of what we're doing today affects what's happening on these issues in the town of Waddy. Nothing what we're doing today affects them one way or the other. If they're doing it right, if they're doing it wrong, if they're doing plans, if they're not doing plans, whatever they're doing, it has no effect. Certainly things they do have effect on Lottie, but nothing we're talking about today has any bearing on Lottie's zoning and comprehensive plan.
Lottie has their own zoning and comprehensive plan. This is just for unincorporated Bradford County.
Right, but they don't have a plan. So if they decide to get a plan,
Right.
Whatever the city of Lawrence decides to do, they do, but this is for the county, which is the incorporated areas of Bradford County. So the cities may have their own, but this is not gonna affect what the city does.
I guess what I'm saying is because what we do is based on what you guys do.
Okay. Well, that's some work that the city have to do, but this right now is the.
I'm the
Thank you,
I'm the zoning.
person.
Yeah.
All right.
Well, the city of
Yeah.
Lottie would need to update their LDRs, their land development regulations, and
Yeah.
comprehensive plan. There you go. There's a card.
I am the person.
Okay.
I'll be happy
All right,
to
thank
talk to
you.
about that.
All right, if nothing more?
Can I ask one
Yes,
question?
Commissioner.
As far as the, when he was talking about the cost of the pavement and everything, are we equipped to give him those numbers? Or,
I would have to defer to Jason on that. I don't think you had made it in yet when we first
Yeah,
talked
no.
about construction costs and prices. I'm not sure, maybe Brandon, if you could restate that.
Yeah, so typically the way that works is it's a collaboration. Their engineer would be responsible for providing a signed and sealed statement of maintenance. Now, mind you, an engineer probably isn't gonna try to shortchange you when his license is on the line, but that signed and sealed statement of maintenance or certification of cost of maintenance would be reviewed by not only your county staff, your county engineer, your road department, and for their expert opinion, but like currently Bradford County contracts with us to review subdivisions and construction plans, so our engineer currently would be reviewing those certifications as well. So if our engineer saw something that, as your county review engineer on subdivisions, saw something that was not kosher, they would definitely be pointing that out, saying, whoa, these are not accurate, we got better data here, this is what it should be.
And I'm sorry, because I'm like Miss Spooner, this is, I mean, off the chain for me, but, you mentioned that the pavement that we have in there, or the asphalt that we have, is no longer used, and so we need to change that,
Correct.
and,
That's one thing I will have to like probably discuss with my traffic engineers about, whether or not they're.
I think we're getting too much in the weeds on that.
A little bit, yeah.
And I understand, because it was very dense and I was kind of getting lost a little bit too. And I work in this area. So the bottom line is this. We don't have to come up with numbers,
okay,
all right? Number one.
okay.
And that's what he just said. And it'll be on a project by project basis. They're gonna say, this is what it costs to do what we need to do, and then we're gonna review that. This idea about requiring a certain amount of certain kind of asphalt result, that's very technical stuff. It gets into, a rabbit hole that we're gonna review as staff to make sure that nothing that you would be approving would be requiring something that's more burdensome than that's required right now.
Yeah.
So it's a very technical analysis of that. And furthermore, the reason why we're even going down that road is apparently which I didn't know until today, that the current thing that's on the books is no longer applicable to like recent standards. So everyone would agree, including somebody who likes that law in Tallahassee, that you can't do what you're doing now because it's no longer applicable because technology's moved on.
Yeah. Yeah, if you were to go to tell them, hey, I want a paper road and I need this type of asphalt, they're gonna look at it and say, well, we don't even produce that asphalt anymore. So they're gonna end up, I mean, that part isn't quite, in my opinion, is important to update right now, because even if somebody has to pave a road, they're not gonna get that. They're gonna have to use the SB1 or SB2 type of asphalt anyways, because that's what they produce.
Well, and I'm sorry to beat a dead horse, but this is just a very important issue to me, because I have a subdivision and I've seen what erosion has done, and it's destroyed this place, and there's nothing can be done now. And so I just wanted to make sure that if we had to provide something, that we weren't behind with the information that we needed. So that was the only reason I asked that.
To the contrary, what we're talking about is making sure that we meet the goal that you just articulated, which is that the most current standards are the standards that would be in place. The only issue, and again, I don't want to go down the rabbit hole, the only issue is whether these current standards that we're proposing are more burdensome than these old outdated standards that no longer apply and cause erosion and all those things.
And I would imagine that if our engineers were to determine that, you know, this thickness of this type of asphalt costs the same, or would have cost the same or equivalent, it would have, you know, we can probably justify it. But either way, I'm not too concerned, because like I said, they're not gonna find the type of asphalt that's in your code currently. They're gonna be stuck with either SB1 or SB2 type.
All right, so Brandon, I think we got a pretty good idea on the direction we want to go. And as the attorney articulated earlier, we'll have everything ready by the first meeting in April. Is that what we said?
March 6th.
March 6th. No, March 6th is going to be their review to say thumbs up.
Yes.
And then April is when they do their actions.
Yes. Okay, everybody good with that?
All right, and everything is good for the good of the order? Then this workshop is adjourned.